Unit 2, Part 2. Let's carry on. The functions and the power of the registrar. Before deregistering a scheme, the registrar must investigate and give a scheme the right to be heard. They cannot just say they're going to deregister. You must listen to the other side of the party as well. So the registrar may, not must, and people, you see in all of my slides, I bold and underline must and may, because for your exam, they might swap the words around. So no one needs a must and no one needs a may. So the registrar may, if they are of the opinion that an application for registration, a rule amendment, or other document relating to the financial position of a medical scheme does not disclose sufficient information to enable a decision to be made, request the principal officer of that scheme to provide such additional particulars as the registrar may deem necessary. The registrar may, not must, he may also request the principal officer of the scheme to provide a certificate or special report from an actuary or auditor relating to any of the above mentioned matters. Section 42, subsection 1 and subsection 2. The registrar may also require such information so as to enable the CMS to make recommendations to the minister on criteria for the measurement of quality and outcomes of the relevant health services provided by medical schemes. That's in section 42, subsection 3. The registrar may address inquiries to a medical scheme related to its business and transactions, and the scheme must reply in writing thereto within a period of 30 days. Please remember the days as well. That's why I highlighted it in red for you. Because in exam, they can ask you, is it 5 days, 20 days, 25 days, 30 days? So if they want to respond, they must do it in writing within 30 days. If they don't do it in 30 days or not in writing, it's a lost case for them. Or such other period as the registrar may specify. So the registrar may also specify another period from the date on which the inquiry was addressed to it. That's in section 43. The registrar or any other person appointed by them has all the rights and duties of an inspector under the Inspections of Financial Institutions Act 38 of 1984 to inspect the affairs of a medical scheme. That's in section 44.1, subsection 1 to subsection 5 of the Medical Schemes Act. The registrar may demand any information, statements and reports that they deem necessary and that are provided for in the Act. The registrar is also specifically empowered in terms of section 44, subsection 4, to order an inspection if they are of the opinion that such an inspection will provide evidence of any irregularity or of non-compliance with the Act by any person, or for purposes of routine monitoring of compliance with the Act by a medical scheme or any other person. The registrar may request an auditor's report on any document that relates to the financial affairs of a scheme. That's in section 44, subsection 6, and may also instruct a scheme to provide a report compiled by an actuary in a form and relating to the matter specified by the registrar, section 44, subsection 7. The registrar may, on the authority of and in accordance with the instructions and directions of the council, from time to time, place any restriction on the administration cost of a medical scheme in respect of any financial year, and may, for this purpose, prescribe the basis on which such costs shall be calculated. Section 44, subsection 8. People, there's a lot of section this and subsection that. I don't really think you need to study all those things so much in detail. If there's a question, it might be one, maybe two, but you decide. I'm not going to tell you not to study it, but what I'll say is don't waste too much time on that. The registrar may, if they are on account of an inspection or investigation in terms of the Act or on account of any report, document, statement, or information furnished to them under Section 44, of the opinion that a medical scheme is not or may be rendered not financially sound, by notice in writing, direct the medical scheme to take such steps as may be specified in the notice that are, in the opinion of the registrar, necessary to ensure the financial soundness of the medical scheme or in the interest of the members of the medical scheme. At any time, you may demand from the medical scheme such financial guarantees and guarantee deposits as will, in the opinion of the registrar, ensure the financial stability of the medical scheme. So he must make sure that the medical scheme has the financial stability right through. At any time, he can come and have an inspection. Subject to the provisions of this Act, take such other steps as may, in their opinion, be necessary to ensure the financial soundness of the medical scheme. Section 44, subsection 9. So he can take any other steps what he decides to make sure that the medical scheme is financially sound. He can demand bank statements, a list of assets, financial statements, whatever, to make sure that the medical scheme is financially stable. The registrar may, for the purpose of directing scheme to take particular steps, direct the medical scheme concerned by notice in writing to amend within a period specified in the notice the rules of the medical scheme in the manner indicated in the notice, or conduct within a period or for a period specified in the notice the business of the medical scheme in a manner determined by the registrar and specified in the notice. Section 44, subsection 10. The registrar may also, if a medical scheme fails to amend its rules as they have directed, within the period specified, amend such rules, and such amendment shall be deemed to be a valid amendment in terms of the Act. Section 44, subsection 11. The registrar may request relevant information from any person whom they have reason to suspect of carrying on the business of a medical scheme which is not registered in terms of the Act, and that's Section 45. So, they might, if they found out you are not registered as a medical scheme, they might either decline, they will not approve in the beginning, deregister you. The registrar may reject any document if they are of the opinion that the document does not comply with the provisions of the Act or does not correctly reflect the financial position of the scheme, and that's in Section 38. So in terms of Section 51, the registrar may, with the concurrence of the council, if they are of the opinion that it is in the interest of beneficiaries or because material irregularities have come to their notice, they may apply to the High Court for an order that an investigation may be made. So then they get documents from the court that they can investigate the rules of the medical scheme relating to the appointment powers, remuneration, and removal from office of any officer or any such other matter as the High Court may regard appropriate be altered. So they can enforce you to alter your rules. A medical scheme be placed under judicial management. So if they think that you don't manage it properly, they can request at the High Court for judicial management. In other words, other people will manage the business then. The whole or any part of the business of the medical scheme be wound up. In other words, closed down. If a person other than the registrar makes such an application to the High Court, the notice of motion and all accompanying documents must, not may, it must be lodged with the registrar at least 15 days before the date of the hearing. You see, this is not 30 days after, it's 15 days before the date of the hearing. You need to give that documents to the registrar. The registrar may, if they are of the opinion that the application is not in the interest of the beneficiaries of the scheme concerned, apply to join the application as a party and file documents in position to the application. The High Court may refuse the application or they might grant the order. Section 56 gives the registrar the power, if they are of the opinion that it is in the interest of beneficiaries or because material irregularities have come to their notice, to apply to the High Court to have a curator appointed to take control of and manage the business of a medical scheme. Section 61 gives the registrar, with the concurrence of the Council and the Minister of Health, the power to declare, by notice in the Government Gazette, a particular business practice undesirable for all or any particular category of medical schemes, or all or any particular category of persons who render contractual, administrative, or intermediary services to medical schemes. So when you look at the extent of authority of council and the registrar, the Act gives the council and the registrar wide powers over not only medical schemes and their trustees, but also entities providing administration or managed care services to schemes, as well as brokers or advisors advising members about medical schemes. The council and the registrar's powers extend to accrediting administrators, managed care entities and brokers or advisors, and setting requirements to which they must adhere to. Not may adhere to, they must adhere to that. Section 67 empowers the Minister of Health to make regulations relating to the administration of the affairs of medical schemes, including regulating, controlling, restricting, or prohibiting any of any act relating to such administration. Regulation 17 deals with the accreditation of administrators and the conditions under which such accreditation may be withdrawn. Regulation 15 details requirements for accreditation as managed care provider and various requirements for managed care contracts. Section 65 states that no one may act, nobody may act as a medical scheme broker. Nobody may act as a medical scheme broker unless, and this is the key word, nobody are allowed to operate as a medical scheme broker unless, sorry, I just want to, as I get my pen ready, unless, so nobody may act as a medical scheme broker unless you are accredited by this council. Regulation 28B deals with the accreditation of brokers. Section 2 states that if any conflict relating to matters dealt with in the Act arises between this Act and the provisions of any other law, save the Constitution or any Act expressly amending this Act, the provisions of this Act shall prevail. Trustees and principal officers. So let's have a look at them. Governance is vital to the way in which trustees run a scheme. Governance is a framework of rules, laws, and practices. So governance is a framework of the rules, the laws, and practices by which a board of trustees ensure accountability, fairness, and transparency. So they must look for accountability. They must have accountability. They must have fairness and transparency in a scheme's relationship with all its stakeholders. Hence, Section 57, subsection 2 provides that at least 50%, very important people, make a note, highlight it. Also a possible question. They can ask you What is the percentage? Well, let's first complete the sentence. At least 50% of the members of the board of trustees shall be elected from amongst members of the medical scheme. So if you belong to a medical scheme, you can also apply to be a trustee of that medical scheme. And now my brother also, me and him are on the same medical scheme, and he also applied every year, or applies every year to be on a trustees. But okay, every year they vote, and the more members vote, then they go for these people. But yes, at least 50% of the board of trustees must be members of the medical scheme, and the other 50% will be other people, other trustees. So that they've got a mix. So these 50% of the trustees from the members represent the members of the medical scheme. All right. Section 57 of the Medical Schemes Act 131 of 1998, referred to as the Act, requires all medical schemes to have a board of trustees consisting of persons who are fit and proper. So everybody on the board of trustees must be fit and proper to manage the business contemplated by the scheme, by the applicable laws and the rules of such medical scheme. It creates confidence in members that trustees are persons that are competent, honest, and sound. So these trustees must be competent, they must be honest people and sound. Sound means they must be good people. The propriety and competence of the medical scheme officers, the trustees, and the principal officers are of keen interest to the Council of Medical Schemes, the CMS. The CMS has periodically conducted vetting of medical scheme officers to determine their fit and proper status, to understand that medical schemes independently vet their officers. So each medical scheme must vet their own officers to make sure they fit and proper. And for you that, for those who don't know what vetting means, vetting is not to take the person to the vet to check if they are fit and proper. No, vetting means to do a proper or a thorough background investigation or checks. Background, let's say investigation or checks of a person. What is their history? Are they who they said they are? Do they have any criminal records that they don't tell you about, which they're hiding? Do they have bad records at ITC or whatever? Do they hide things from the past? Or are they open and truthful? So sometimes vetting, they will find out more that you know about yourself. So if you've got anything, uh, don't hide it. Tell them up front. I had this issue. I had this problem because of this or this reason, but I'm okay now. Everything is sorted out because they're gonna pick it up in any case. I know of a person that had the criminal record, um, but they got it expunged because it was just for driving under the legal limit. So it was a light offense. He told me that he went for police clearance. He got the police clearance that said that that record has been expunged. Well, but he's got no record because after the expungement, he told me that it was fine. And then when he applied for a job, the job went to vetting, and then the job found out that he had a criminal record, which was not supposed to be, but they dig in deep. So he said at the end of the day, he didn't get that job. He was honest. He told him that he doesn't have a criminal record because of the police clearance said that he's got no record. But when the company wanted to work for where they did vetting, they picked up that he had a record, which is expunged now. So he's got no record, but they picked up that he had one, and they confronted him because he wasn't open and truthful about it. But he thought that he said to me, Yaku, I thought that when I got the police clearance that there's no record, so why mentioning it? But when they did vetting, they picked it up. And then I told him you were supposed to tell us about it. So yes, that is vetting. They dig deep. So please, if you've got anything to hide, rather be upfront and tell the people that the same things doesn't happen to you like with my friend. It has emerged that not all medical schemes have methodical vetting processes. Methodical means they do things carefully, thoroughly. You see, carefully, thoroughly, and in order. Okay, so not all medical schemes do it that way. Some do. To this end, the CMS has decided to embark on a joint exercise with the medical schemes in the vetting of medical scheme officers. The CMS undertakes to conduct vetting with the utmost confidentiality and by Section 60 of the Act, which deals with preserving secrecy by the Council and its staff members. The information provided will not be disclosed or used for any other purpose than to assess the propriety and fitness of medical schemes officers, except insofar as it may be required and permitted by law. In the effective discharge of this obligation, trustees, principals, officers, and members of a committee of the Board of Trustees are requested to furnish the CMS with the applicable vetting questionnaire completed accurately and legibly. Remember what I said on the previous slide. That vetting document you must complete accurately and legibly, together with a copy of the officer's current curriculum vitae and identification document, this ID book. A separate sheet may be used to provide more details on any of the information provided or to provide further information which you believe has a bearing in assessing whether you are fit and proper to serve as a trustee or a principal officer. So let's say something did happen in the past, but that was many, many moons ago. You are not that same person, you've changed, or maybe you went through a divorce and financially you were ruined because you had to give half of the stuff to the spouse. And because of that, you went into liquid sequestration. You couldn't pay everything because you had to pay alimony to the children as well. And you just went downwards. So you had to work your way up. So you were bad records at ITC. So, but during the years, you recovered, you paid all your debts, you've got no more debts, you bought a house, a car, you got a good job, you got a good income, and now you're okay. But that records might still be there or show, or they can pick it up. Then you can just explain to them, listen, it was because of the divorce. The spouse took off of everything, plus I had to pay those stuff and I had to pay alimony, and it was just too much. And I was in a bad space, so I lost my job because I couldn't focus. So but I'm okay now. I settled everything, paid everything. So then they will understand it. But be open, tell them about it. It is vital to take cognizance of the fact that trustees have a fiduciary responsibility to both the scheme and its members, and thus they could be held criminally liable for decisions made that are not in the interest of the scheme and its members. The principal officer is the executive officer of the scheme. And appointed by the trustees of the scheme mentioned in section 57, subsection 4A. The word cognizance, if for those who don't know, the word cognizance means to take notice of and consider something, especially when judging. So it is vital to take cognizance. So it's vital to take notice and consideration of the fact that trustees have a fiduciary responsibility to both the scheme and its members. That's basically what they want to tell you there. You must take notice and have consideration of the fact that trustees have a fiduciary responsibility to both the scheme and the members. So they can be held accountable if they do things by the scheme or by the scheme's members. As the executive officer of the scheme, the principal officer needs to ensure that basically the principal officer will be the CEO, Chief Executive Officer. They need to ensure that the following: the decision and instructions of the board are executed without unnecessary delay. Always act in the best interest, always, not sometimes or only on Sundays or Saturdays. Always act in the best interest of the members of the scheme. Always. Keep the board sufficiently and timeously informed of the affairs of the scheme concerning any matter or any matters relating to the duties of the board as stated in section 57, subsection 4 of the Act. Where necessary, there is proper and appropriate communication between the scheme and those parties affected by the decisions and instructions of the board. So communication must be open. Does not take any decisions concerning the affairs of the scheme without prior authorization by the board, and that he or she observes the authority of the board in its governance of the scheme. Must keep the board sufficiently and timeously informed concerning the affairs of the scheme to enable the board to comply with the provisions of section 57, subsection 6 of the Act. Also, the principal officer is the accounting officer of the scheme charged with the collection of and accounting for all money received and payments authorized by and made on behalf of the schemes and all actions attached to this responsibility. The principal officer also needs to ensure that all his or her duties are carried out for the proper execution of the business of the scheme. When you look at financial advisors, intermediaries, or brokers, to be accredited as a healthcare broker, you must be accredited by the Council for Medical Schemes, by the CMS. And please note, you don't get a license from the CMS, you get accreditation. If you register at the FSCA, then you get a license. But with the Council of Medical Schemes, you get accreditation. The broker, the financial advisor or intermediary must have the recognized qualification and experience that is in Regulation 28B. They must be fit and proper, as we discussed earlier. Requirements as stipulated in Section 7, subsection 1 of the FACE Act. They must obtain a license from the FSCA, the Financial Sector Conduct Authority. So you see, they get a license from the FSCA. They don't get the license from the CMS. They get accreditation. Okay, so they must have both. They must have a license as a FSP, which they get from the FSCA. And to sell medical schemes, you must get accreditation. Don't confuse the two. So the complexity of health insurance products, including medical schemes, gap covered products, primary healthcare, PHC, in other words, products, hospital cash plans, disability and income protection plans, has ensured that both individuals and corporates need informed and qualified advisors to guide them to the most appropriate products. The current medical environment requires advisors to take a holistic view of insurance options available and craft solutions that will provide the best available financial protection. The key to sound financial advice is to keep abreast of new product offerings and to match these with the client. So make sure that if things change, you stay up to date and you can go back to the client and say, okay, we discussed this and this about that medical plan last month or 2 months ago or last year, but things have changed. I think it will suit you better now. Let's have a look at it again. All right. And that's the end of part 2 of Unit 2. If you've got any questions, you know what to do. See you in the next part.